recording is to go along with the material in Chapter 8, Performance and Discharge, which I have up, or my notes of it, up on the screen. So, as a setup, we're looking at a situation where, let's make it simple, two parties have entered into a contract. And we want to understand the circumstances that will permit us to say that the obligations that those parties have incurred by entering into the contract have been discharged. That in part, that consideration in part will then also require us to talk about performance. And you'll see that I've listed four different categories of discharge. And in the category of discharge by performance, we want to talk about types of performance and then material breach of contract. I might add that we also want to talk about time of performance as well. But let's go first to discharge by condition. And let's take a basic contract that in the course of our lives many will enter into. That is a contract to buy or sell a house. Now, typically in that type of contract, the person or persons who are going to buy the house need to obtain a loan from some lending institution in order to pay the purchase price. And you'll see this in the real estate practice course, but if you were to look at your typical contract of sale for a house, there's going to be a condition in there, and this is after the parties signed it, and that condition is that within X number of days after the parties sign the contract, and don't forget it's got to be a signed contract because of the statute of frauds, but that within X number of days the buyer is going to use good faith efforts to obtain a loan. And typically there's some language about the type of loan, how long it has to be, interest rates, etc. But we could call that a condition precedent. And as you'll see, it's a condition that must be fulfilled before a party's performance can be required. So in this case, unless the lender decides to provide a loan within the time period prescribed, unless that happens, unless that condition is fulfilled, then the performance of both the seller and the buyer, and it may be very disappointing to both of them, but their performance is no longer required under the contract. And you'll see that I have mentioned real estate contracts as a example. I know that in the chapter and in my posting I talk about a condition subsequent, and I also talk about concurrent conditions. But on second thought, I don't think at this point we need to get into them any further. I prefer that you think of the real estate contract because that's the one you're going to run into, and the whole idea of the condition precedent. With that in mind, I'm going to talk next about discharge by performance, and we could say at the outset that one way to discharge a contractual obligation is to perform the obligation. Contracts end up that way. There's a little bit of a wrinkle, though. There's two basic types of performance. Complete performance, which, as I've mentioned, discharges an obligation, but also something known as substantial performance. And when we look at performance, we have this really cool case in the book, Jacobs and Youngs versus Kent. And in that case, a builder builds a house and in the process installs a different brand of pipe than provided for in the contract. And what typically happens in a building contract, as part of the contract, are the what we call the specs. And the specs here required a certain kind of pipe and a certain brand, I might add, of pipe. And what happens is the builder puts piping in the house that is exactly like the piping and the brand called for in the specs, but uses a different brand. It was a mistake. And you'll see the only difference between the brand of pipe used by the builder and the brand of pipe called for in the contract was the name of the company manufacturing the pipe that was stamped on the pipe. And that in all other respects, the pipe was of the same quality as the pipe that should have been used. And when the owner discovers this, the owner says to the builder, I'm not going to pay it until you fix the problem. Well, in one sense, that's kind of ridiculous, because to fix the problem, and by the way, what was the problem? A different brand of pipe was used, though it was exactly the same as the brand called for. To fix the problem would have required ripping out all of the plumbing and putting in the new pipe. And when the case went to court, it eventually reached the highest court in New York on appeal, the New York Court of Appeals. The court identifies this notion or concept of substantial performance. And I quoted from the case, that is a party who in good faith, and it should be performs, I'm sorry, typo, performs substantially all of the terms of a contract, can enforce a contract against the other party under the doctrine of substantial performance. And the way that works is the court finds that there was just a trivial deviation that was done inadvertently and didn't affect in any meaningful way the purpose or compromise the purpose of the contract. And therefore, even though the builder didn't engage in complete performance, the company engaged in substantial performance, and thus the builder was entitled to the contract price less any damages that may have been caused by a lack of complete performance. If you think about it, in this case, there's probably no damages at all. So that's what substantial performance is about. If, however, the performance rendered by a party is less than complete or substantial, then what we say is there's been a material breach of contract. And a couple of things happen at this point. If there's a material breach of contract, then typically the other party who's not in breach is excused from performing until there's a cure of the breach. And if there's no cure of the breach within a reasonable period of time, then that party's obligations are discharged. So what we can say is a material breach of a contract can discharge future performance by the other party. Moreover, and we'll see this in the next chapter, the party who has been subjected to a material breach by the other party has the ability to go to court and seek some type of remedy. And we'll talk about remedies for breach of contract in chapter 9. The last point I would want to make about performance, it's kind of important, is the time for performance. You know, how does that factor in terms of complete performance or breach of contract? And the rule might be a little bit counterintuitive, so it's important, I think, that we take a minute and identify it. And that is a contract must be performed by the date stated in the contract or within a reasonable period of time after that date. By the way, if there's no time for performance stated in the contract, then we again stick with this reasonable period of time and simply say that the contract must be performed within a reasonable period of time. Let's assume that a party wants to have performance done precisely by a date. They want to, if you will, have a drop-dead date in a contract. And you can achieve that purpose by stating, of course the other party's got to go along with it, but by stating in the contract, time is of the essence. And the other point I make, just to jump ahead to the next chapter, is another way perhaps of guaranteeing performance by a certain date is to have a penalty clause for liquidated damages in the contract, which may be a motivating factor for a party to perform the contract on time. I just want to then quickly say discharge by agreement. It strikes me as a little bit of common sense. If you and I are involved in a contract, we can end the contract by agreeing to do so. There are some distinctions that lawyers have to worry about, but we don't at this point. And let's just say that a contractual obligation can be discharged by agreement. And then we have an area discharged by operation of law. And the most significant ones are statute of limitations. And what does that mean? Well, as you'll learn in the civil practice course, there is a statute of limitations for civil claims. I must, if I believe I have a legal claim, bring the claim within a certain period of time under that rule of law set forth for that type of claim, and that's called statute of limitations. You'll also learn that for contracts, there's two different statute of limitations, either 4 years or 6 years, depending upon the type of contract, that we don't need to worry about at this point. But certainly, if a party is claiming breach of contract and that party does not bring the lawsuit within that period of time, we could say that the obligation of the other party has been discharged because they no longer can be sued. The statute of limitations has been has expired. Bankruptcy, some contractual obligations, not all, but some can be discharged in bankruptcy. Donald Trump, by way of example, and really it was his corporations. I'm not trying to pick on him. It's just as an item that's been in the news. Discharged a number of contractual obligations through bankruptcy court. By the way, you cannot discharge your student loan in bankruptcy court. It's kind of an interesting point of comparison. There also could be impossibility or impracticability of performance. You and I have a contract, and the contract calls for me to sell you my house, and before the contract can be fully performed, the house burns down. Well, that ends our obligations to each other under that contract. That's it for this recording then.